So then what are the regulatory bodies within India under its safety regime? There are three main bodies which have been set up through the genetically engineered rules, and this is the review committee on genetic manipulation called the RCGM. Then every body or research institute which does research and development on LMOs and GMOs is supposed to have an institutional biosafety committee. And then at the central level, at the Ministry of Environment and Forests, is a Genetic Engineering Appraisal Committee, the GEAC, which is supposed to not only clear large-scale field trials, but also assess the safety of LMOs or a GM product, to approve or to disapprove its use and its commercial application. So there is a detailed procedure that is followed. Biosafety protocols are set up at the research level when they are in contained conditions within a laboratory setup. But when they cross that laboratory stage, an experimental stage, and have to be experimented in the open field, that's the time when the GEAC comes into play and the role of the GEAC gets activated, because then the proponent has to file an application giving details of its product, the LMO that has been developed. And interestingly, the Ministry of Environment and Forests has been given the last call to decide on the recommendations given by the GEAC. So the Indian experience with GMOs and LMOs is most vibrant in the case of genetically modified crops. And apart from the regulatory regime contained in the executive rules, this issue has been before the Supreme Court of India since the late 90s, when the first 100 grams of BT was imported into India. And since then, since the late 90s, there have been public interest litigation that has been going on in the Supreme Court. And the current case that is pending before the Apex Court is that of Aruna Rodrigues and others versus Union of India and others. The full petition and the grounds on which it has been filed are all available online, and I would encourage you to read the text. And so that is an ongoing a process within the court of law, and therefore it's important to see what role even courts can play in the developing biosafety regime in terms of either imposing stay orders or asking for a certain independent safety body to be set up, or to pin liability on the institutes that are undertaking R&D. And there have been other legal fora within the country and outside which have also had to deal with different aspects of LMOs. And it's useful to recall here the Monopolies and Restrictive Trade Practices Commission, a body which has since become defunct and has been substituted by the Competition Commission. But on the issue of pricing of GM seeds, again, state governments had taken some of the seed companies, particularly the large multinational corporations selling GM seeds, on the issue of pricing. So it's not only the biosafety issue, but also pricing issues as well as other issues that we will get into in the later end of the presentation that are important to see to capture the trend of how biosafety legislations are developing. There are also several committee reports that are useful to read and understand. These are committees, technical expert committees that have been set up by the Court of Law, the Supreme Court in the Aruna Rodrigues case, as well as multi-party parliamentary committees which have given their opinion and their recommendations on developing adequate biosafety legislation before going ahead with GMOs and LMOs. There have also been very vibrant people's campaigns and submissions made by concerned farmers and scientists on this issue. So what are the standards of biosafety? Who prescribes that? There has to be some kind of scientific consensus on this issue. But like I mentioned before, the United States of America has its own standard on biosafety, and that is quote unquote substantial equivalence. That means it believes that LMOs and novel foods that are developed from genetically modified crops are equivalent or substantially equivalent to natural products which are not GMO. So it doesn't need any specific or special or more stricter legal standards for its regulation. And this has been the basis on which it is attempted to stall the biosafety protocol. There's another issue, that of intellectual property, which the United States of America has also pushed to get introduced in the World Trade Organization's IP agreement called TRIPS, in which everything is to be made patentable. What I'm trying to give you the link to biosafety is that there are other laws apart from biosafety laws, such as patent legislations or seed legislations, which also have a bearing on the issue of biosafety. For instance, our Plant Variety Protection Act 2001 in India requires that every application for registration of a plant variety must have an affidavit which states that it does not contain terminator technology. So there is no ban on the registration of GE varieties for IP protection, but biodiversity conservation is also a concern. And here, even the Central Biological Diversity Act of India, legislated in 2002, imposes obligations on the central government to take measures for biosafety. So biosafety is not just one regulation or one protocol that comes into play, but it can be covered through a whole range of legal measures. Let's summarize then. Biosafety is about ensuring the safety of human and ecological health when using LMOs. It relies heavily on the use of law, both at the national level and the international level, but it also requires a technological infrastructure to be able to test and detect for GMOs. Then the international law on biosafety is under the CBD, which has two specific sub-protocols on this issue under it. There are also 3 environmental law principles that form the basis of biosafety legislation. And then the law on biosafety in India is still developing, though we have a biosafety regime under the executive rules of 1989. And finally, several other laws have a bearing on the issue of biosafety. Thank you.